So with me, I've got an esteemed panel of experts. Susan, why don't you introduce yourself? She's a pioneer.
Yes, so I'm Susan Dunn. I'm a founder of Harbour Litigation Funding. I've been funding for 20 years. So it's been a very long time that I have seen the changes that have happened over that time, and this notion of ESG and what we talk about is actually something when I look back over the cases that we have done, we've been doing all of those for a very long time. So it's interesting that this new thing that we're talking about doesn't feel very new to me, but I have some views about how it could be better used by a number of people in a way that I don't think is always talked about.
Brilliant, and we will definitely circle back to that. Simon.
Good afternoon, I'm Simon Walsh. I'm from Cadwalader, Wickersham and Taft in London. I have practiced international litigation and arbitration for about 20 years. I've also been a funder in my time, so I've seen both sides of that coin. I act for ESG ratings providers and do some interesting work with them. And I'm glad to be here today. Thank you very much.
Thank you. Élodie?
Hello. Good afternoon as well. So I'm Élodie from BCLP, Bryan, Leighton, Paisner, from the Paris office. I guess I'm pretty much one of the few here who is not an English native speaker, so sorry about that. I'll do my best for you to understand me. I'm really excited to talk to you about ESG claim and ESG litigation because, as you all are aware, it's coming up. Great.
So we will give you an overview of the kind of key legal developments and then really move to talk about the trends and observations that we have of ESG claims and how they relate to class actions. Now on that, so just to level set, so ESG obviously a massive agenda item on both the political and legislative agendas. We've seen some really key developments, sort of headlined really by the EU, but also laws coming out in the UK, regulatory initiatives in the US, as well as Australia, China, Singapore, the rest of the world. So key item backed by really political objectives around harnessing the sort of the private capital markets to fund and facilitate net zero and transition to more sustainable economic and reproductive structures. So against that background, we'll talk a little bit about some of those developments, but also it's useful to think about this as kind of like something that is about to become a more relevant and prevalent political consideration. And so although there's a lot of discussion about, consumer protection, for example, or other normative premises, we feel that really climate change related and more broadly ESG related claims, they have a lot of regulatory and political attention. So key topic. So on that, kind of very briefly, what would you see are kind of key principal bases for class action claims on the ESG arena? Élodie.
Well, Ezra, if I may start, we can all agree that ESG initiatives have multiplied in recent years. In EU with the SFDR taxonomy and SRD regulation, and in particular in France with the Pact law and the corporate duty of care law. So what we can call today ESG instruments have been now implemented into national law, and they have both become a new communication tool for companies, but also a new source of responsibility for the same companies. So when we talk about ESG commitments, risks are high. We can all understand that. They are high, being reputational, being market-related, or being subject to regulatory fines. So today, I guess we're going to talk about greenwashing risk, but also parent company risk and sustainable finance. That's what I see as relevant.
And Simon, do you, in terms of the kind of principal areas where ESG claims are likely to arise, in addition to what Élodie has mentioned, do you see any additional areas?
Yeah, well, there's certain themes, I think, developing, and it's quite interesting. We've heard it on the last panel, actually, that when people talk about ESG, there's so much focus on the E all the time. It's all people really think about when they think about ESG. But it's not all about E. And I think although there's going to be a lot of claim focus, and E will be a key theme for claims, simply because, as Élodie mentioned, there's increasing levels of regulation because of the heightened interest that you talked about, and this tension whereby governments internationally are setting targets that they can't meet on their own, actually, and they're having to put pressure on big businesses to meet those targets, and you've seen it with Shell. I think though those claims are still quite problematic, and certainly, I mean, we've got a funder on the panel. There needs to be money in those claims a lot of the time, or at least clear. Certainly, when I was a funder, if someone brought you a proposition, there had to be a clear damages theory, and still, certainly in terms of climate change cases, I think there are other environmental cases. The Fundau Dam case was mentioned earlier. Might be slightly easier, maybe not simpler, but easier. Those damages theories are difficult, and so they're difficult to fund. So I think the theme will actually be more towards S and G, and again, it was mentioned on the last panel. I think G's always been a big theme. It just wasn't, in my day, they weren't called ESG claims. I've been doing them for years. But I think S, so social factors, is going to be really big. We're entering a high inflation environment. Wages are going to be squeezed. There's not going to be wage growth. Look at what happened in our UK budget the other day. Disposable income is at the lowest level it's been at in decades. And that means that where globalized supply chains are involved, there's a pressure because businesses don't want to raise prices. They've got to find that cost somewhere. And traditionally, that has meant that supply chains move into jurisdictions where there are less controls on human rights, and there's less control on conditions for workers. And that's, I think, where the key risk is going to be for ESG claims moving forward.
Yeah, and I guess that will tie very neatly into some of those European developments, like the corporate sustainability due diligence requirements that will give some additional depth. And so I'm just going to circle back to a buzzword there. So can we just very briefly talk about greenwashing and what you take greenwashing to be? Simon, I'll start with you.
So greenwashing, I see it as two pieces of the same picture, and there's a wider description of greenwashing, which is businesses that are putting out misleading advertising, essentially, about either their own green credentials or the green credentials or the sustainability of the products that they're marketing. That's been around for quite a long time, and you may have seen that recently in the UK, there was quite an interesting decision from our advertising watchdog about an advert that HSBC had put out, and HSBC said, we spend £1 trillion on planting trees, and the advert was actually taken down by our watchdog because they said, you may spend £1 trillion on planting trees, but what you haven't mentioned is your carbon emissions are some of the highest that we've seen, and you're not necessarily meeting the steps we'd like you to meet in terms of telling people that that's something else that happens within your business. And so there's that generalized term. And then more specifically, going back to some of the regulations that Élodie has mentioned, such as the SFDR, there are now quite specific obligations in terms of how you market financial products. And this we could talk about all day, but I've been warned we shouldn't. There are several different pieces of a jigsaw of regulation around the nomenclature. So you've got the EU taxonomy, which is essentially it's a lexicon, a dictionary for the terms that you're allowed to describe your green products as. And then the SFDR gives you a playbook of, okay, so the products that you want to market have to comply with certain criteria in terms of how you disclose their principal adverse impact risks. And these are quite onerous, I think, if you look at them. So it'll say it requires you to disclose the social impact. So that includes sort of gender pay gap, and also the environmental impact. So it could be how much energy is used by the investee companies that are being marketed within, for example, portfolio financial products.
So it's a real quagmire of trying to find reliable data.
Absolutely. There's a huge amount of disclosure that needs to be made.
And Élodie, do you think from a French perspective, is there something specific on greenwashing?
Yeah, if I may add, when we speak about greenwashing, we can all agree that we see everywhere messages such as on your Nespresso capsule you see neutral carbon, at the airport you see fly responsible, on the water bottle on the table you can see end of plastic waste. Well, messages intended to contribute to a sustainable future are now of course multiplying. And while these messages illustrate the desire for companies to choose environmental friendly approaches, the risk for the same companies is to, of course, mislead the public about the reality of one's action or the sustainable development properties of the product in case. So that's the practice known as greenwashing. And like Simon mentioned, the EU is pretty much fine-tuning its text. France, in particular, has included greenwashing in the field of misleading commercial practices, and I guess we'll talk about that later on. Germany has reached the stage of searching the premises of Deutsche Bank, and the UK advertising regulator, the ASA, has banks in its sights. So we can see pretty much that greenwashing is now being pretty much hunted down.
It's true, isn't it? So the greenwashing, I was reading this morning that apparently the European securities regulators, so the European Banking Authority and ESMA, they are inviting whistleblower reports on greenwashing on companies. So it seems that there's really some active movement in trying to identify claims. And Susan, from your perspective, what's the sort of the funders' view on willingness and interest in funding ESG claims?
Yeah, well, I mean, to Simon's point, every funder starts from the position of, is this a case that's going to make money? I think the switch, certainly, that we had when I think back, we've been funding shareholder class actions, that's about governance. We're funding about 100,000 women in their equal pay claims against supermarkets in the UK. And then, indeed, we've been funding 15,000 Indonesian seaweed farmers for 7 years in their claim against an oil company in relation to an oil spill that caused damage to what they're doing. That's just 3 examples of when you look at each of those, they are each of the types of case. But the hardest are definitely we're going to help the climate change agenda go forward, because unless we can show that there is money that changes hands, as opposed to declaratory relief, which the countries or companies should be doing, then we have to be able to make money. So all of those cases I've just described, to my great delight, we simply said, well, of course we can do them because they make us all money, and collectively they would never be able to happen without funding. So it's a great joy to me that we sort of, without thinking about it, fell into our own ESG agenda, and the money we look after is educational endowment and pension money, who themselves have a long time had an agenda of saying, we don't want you funding these types of people, and you can't use our money for these types of things. So tobacco companies and going back all that time, those agendas have already been there which is why it doesn't feel like a new thing to me.
And that may be partly because of your investor base, I think those institutional investors.
Yes, and a personal mission to say, well, why on earth shouldn't we do these types of cases? And everyone went, oh yeah, let's do these types of cases, which is great, right?
And I'm just going to circle back on another topic. So you mentioned also parent company liability. Not in itself all that new, although I gather that there are some developments on that front. Simon, do you want to start?
Yeah, of course. I mean, I think this is it's quite interesting and possibly dangerous if you're a listed company in London, because there have been several decisions at the highest level, at the Supreme Court level. Recently, there's the Vedanta and Royal Dutch Shell cases that show that London listed parent companies who have subsidiaries in, I believe one of them was Nigeria, can be held liable, potentially. There have only been findings on the threshold issues of jurisdictions at the moment, not liability, but could potentially be liable for the actions of their subsidiaries where there are human rights abuses or environmental issues. And that's quite a big, it's not necessarily a leap legally, because they're essentially just saying, well, there's a duty of care, of the parent company towards those subsidiaries and the people it's affected. But it's leaving London headquartered businesses in a bit of a quandary, because essentially the court said you can owe that duty if you have a sufficient level of de facto control over what the subsidiaries were doing. And so if you're a London-listed entity, if you're Shell, you might think, well, okay, we were looking very, very closely at what was happening in Nigeria or wherever it may be. Actually, we might stop doing that, because then we no longer have de facto control. We'll leave that to them. But then you put yourself in danger of breaching many of the other jigsaw of regulations that are coming into place about ensuring that your business acts in a sustainable way. Or, if you do maintain a de facto control, you're at risk of these kinds of claims that are being brought by people against Vedanta and Royal Dutch Shell.
And is this a trend that's also present in France?
In Europe and in France in particular. When we talk about parent company risk, we may as well say domino effect. It's pretty much it. I think that sum it up. The French corporate duty of care dates now from 2017, so it's a few years back. It imposes a duty of care on large companies based in France with regards to a wide range of risk related, of course, to human rights and environmental damages that their activity may generate via their subsidiaries and suppliers and subcontractors with them, with whom a commercial relationship is established in France or abroad. So you can really identify the domino effect it's high on companies, that domino effect, and one wonders where it's going to stop. Under French law, so far, only a few companies such as Total and Casino are being sued on the ground of the corporate duty of care law. So far, we do not have decision on the merits, but of course, the decision you mentioned earlier on about Shell in the Netherlands could be an example. And on an EU perspective, we may add that the EU proposal for a corporate sustainability due diligence directive, which is pretty much inspired from the French model and also from the German model, it could be a game changer. In particular, the text expressly targets regulated financial undertaking, including, banks, financial institutions. And for instance, in France, recently, just a few weeks back, one bank has been targeted by NGOs on the ground of the duty of care. So we can really identify that domino effect.
And I guess there's some precedent in the US on, private equity managers who've had their own people, their portfolio managers on the board of directors, where ultimately the manager itself was sued on this kind of parent. So on that, deep pockets they may be. Is this of interest to the funders?
Yes, of course. And that's the first question any funder asks of any case, no matter what it is who's the defendant and can they pay? And also what percentage of their overall net worth does this claim represent? And one of the things that we've seen is a lot of cases against big tech in relation to, and by their own admission, if you look at Uber admits that in its land grab early on, it breached all the rules. And then it said, well, we'll tidy that mess up later on. And then, of course, later on, they come to people like us on behalf of, we funded Uber drivers, we fund zero-hours contract people in their claims. To claims against them. The big tech ones are, if you think about competition, antitrust matters, that's all the governance side of things. And if you look at the claims which are brought, and we've been talking about 19.6, to make people behave, because these cases on their own are just not big enough to justify the huge budgets that are involved. So it's only if you've got funding in these forums to bring these collective claims together that there's any chance of them proceeding. And they are huge. But you know what? These defendants are really good at stringing the thing out for years and years and years and years. And duration of cases is something that claimants but funders are very interested in. And that has a very jurisdiction-specific impact on where we will and won't consider bringing cases if it's simply going to take too long to conclude.
And on that, are there other procedural challenges, Simon?
Yeah, certainly in the UK there are. There's quite a there's quite a good and nicely developed regime now for competition claims, and you may start to see more of those in the ESG space, actually. There's an interesting dawn raid recently in the EU on several fashion brands who, and I think this actually highlights some of the dilemmas that are going to be faced by a lot of businesses going forward in relation to the regulations that are increasingly coming to the fore in the ESG space. Fashion brands were getting together and trying to work out how they could reduce water usage, how they could reduce waste, how they could reduce their carbon footprint. And there was a dawn raid based on that being a cartel, potentially, because it excluded other businesses who didn't have the ability to necessarily look into those issues in the same way, or might allow those companies to put a higher price point on those products as a premium product. And I thought that was a fascinating angle that I hadn't necessarily appreciated. And the same sort of allegations were made against the Glasgow Net Zero Financial Alliance, or forgive me, I'm sure the name's wrong, but there were suggestions that that was another cartel with its aim being to prevent the proliferation of carbon. So essentially it was an attack on, petroleum, which I thought was, these are perhaps claims that are not going to go anywhere, but you can see that clever plaintiff lawyers are potentially going to use these angles. But that aside, I think that the claims are always going to be brought, whether they're good or not is obviously a separate question, but I mean, claims are always just they'll be brought.
Élodie, are there any specific procedural points that would be relevant in France?
I can think that in a recent case opposing an NGO to Nespresso, the Paris Judicial Court was asked pretty much whether the greenwashing action was subject to a limitation period. So under French law, the action based on deceptive marketing practices is subject to a 5-year statute of limitation. And the thing is, the plaintiff must exercise his action within a period of 5 years from the day when he he should have known the fact allowing the exercise of an action. So when you're talking about environmental action, environmental allegation, when it appears in one document, for instance, in a press release, there is no difficulty in determining the starting point. However, the situation is less clear when the environmental allegation is made on material distributed as part of advertising campaigns. If such a company claims that the products are carbon neutral in its television and print advertisements, I mean, the Paris Judicial Court was asked whether the plaintiff, the NGO in fact, could be considered as to have known or should have known of the environmental allegation. Well, in a recent decision last May, the Paris Judicial Court ruled that yes, he should have known. So it's time-bound. Well, of course, an appeal has been lodged, but it's quite an interesting way because, I mean, it's a way to dismiss the case quite early on. So
and are there any notable examples of ESG litigation that you think will be particularly influential going forward? Simon?
Yes, I think there's a couple of things going on. Actually, just to complete the procedural question, the problem we really have in the UK is that outside of the competition space, there's no good defined way for group actions to be brought yet. It's getting there. The plaintiff bar is developing very, very quickly. Funding is now much more widely available even than it was a few years ago, and it's more sophisticated. So those procedural barriers are starting to drop away. But in terms of the claims that are coming forward and are influential, I think Lloyd and Google in the data space was influential in good and bad ways, in that it's highlighted the procedural problems that we have in the UK in terms of bringing mass claims, easily at least, or without a very significant upfront financial burden for a funder in terms of book building, which is a theme you've heard over the last 2 days. But it also highlights the fact that, there are genuine, legitimate claims and rights that need to be protected in that space that aren't yet, they don't have the forum to do it. And so I think that's an influential case. The other influential case, I think, is one that was also mentioned earlier, is the Shell case that was brought in Holland is also being brought in the UK. And I'm slightly worried about describing it from the Dutch perspective, given the room I'm sitting in. But as far as I understand it, there was, the claim against Shell was that they were not implementing a climate change strategy that was sufficiently rigorous, and they should have been targeting 45% carbon reduction by 2030, I think it was. And the basis for that claim was an unwritten standard of care, so essentially a sort of tort claim against Shell, that there's a general duty to be good to humanity, and there are human rights abuses potentially in not following through with climate change aims. That has been taken by some UK claimants, and they are now bringing a claim by way of a derivative action. So there's a shareholder, investor, activist who's bringing the claim against the directors personally of Shell on the basis that they have not implemented a climate change strategy. What's interesting is the aim of it is sort of noble. It's to make sure that Shell is complying with its part in the 1.5 degree pledge and the Paris Alignment Agreement. However, it's pitched as Shell's directors are not exercising their reasonable care and skill and duty as directors of a company to ensure the commercial viability of it as a business. So it's quite a clever claim, I think, but it also highlights that ESG claims as such don't have and do need, given their prevalence, a specific defined mechanism that allows them to be brought, rather than having to lever them into existing torts and mechanisms by a somewhat circuitous route.
And Susan, would you think about funding a claim of this description? Do you think it's just too hard to quantify damages?
I think, well, there's the damages question, but it's the legal basis for the claims as well, because this is sort of in the loss of opportunity realm of you could have done this, you should have done that. And I know that COP27 has been talking about these reparation funds and that sort of thing, but it seems quite thorny to be able to do so. So we keep coming back to the same things, that if a fund is going to fund a case, the case has to be shown that it's got a better than 50% chance of succeeding. And people come to us and say, you should take a punt on this. Well, we're looking after other people's money, and they don't ask us to take punts on things. So whilst they're keen on promoting these agendas generally, they nonetheless give us a hard time if the cases we fund don't succeed, no matter how worthy they might have seemed. So, which is why the sort of the S and the G side of things is the sort of much more commonplace thing that we see. And the other thing I would say, though, is even when I look at, the budgets for these cases run in the tens of millions of pounds, and the claim values are up to the billions. But the companies that we're talking about having a go at, that still doesn't really even move the needle much, so they kind of don't care. There's not enough, I don't think they feel enough vulnerability yet about these cases, so it's like, oh, it's another piece of litigation, put it on the pile. And we've got to see that balance tipping. There's got to be pressure that comes, and one of the things that they need to feel the pressure from is the speed of action, that most jurisdictions are simply too slow. Just too slow in the way that we do things. Jeffrey Voss in the Lloyd and Google case in the Court of Appeal said, if the court can't help solve these, what's the point of us? And he's right. But what the judiciary has also got to look at, and court systems generally, is how do we do it more quickly? Because until they start feeling that pressure of these things all piling up, but they look at them and they know these things are going to take 5-7 years, and the GC at the time will say, well, I'll kick that can down the road. I might be at my next gig by the time this comes through. I'm not going to recommend settlement. And these are all the issues that you've got. There's just not enough pressure there.
Yeah, so maybe at some point, if there really is political will, to kind of move
we've got
the
to
decisions
speed up
through the courts.
We've got to speed the court system up. In all these jurisdictions, the VW cases, there was a report about that this week of how they are picking off jurisdictions as the ones that they see it coming looming towards them. And you look at the countries that they've not settled in, it's the ones they know are going to take a long time, automatic rights of appeal, take forever, doesn't cost them much to defend it. Brilliant. Well, that tells you everything you need to know. We've got to all get our act together and make these processes much more quick.
And Élodie, do you have a particular case in mind that you'd...
Well, yes, again, I've got some case in mind as we got greenwashing, but also as we got parents' company risk. As we got greenwashing, as I mentioned earlier on, a German bank, DWS, and its fund management subsidiary were pretty much raided by the German judicial as part of a fraud investigation into investments that were presented as greener and more sustainable than they actually were. So that's quite a good example. That may happen somewhere else. And last October, the UK advising regulator, the ASA, fined HSBC, another bank, for misleading posters promoting its commitment to tackling climate change. So, of course, we see that kind of poster pretty much all over Europe. So, and you mentioned earlier on the call of evidence launched by the EU regulators. So, other countries in Europe and maybe elsewhere may be targeted by such claim. And as regards the parents' company claims, I mean, of course, we have all in mind the Shell example in the Netherlands and in the UK, and we are all wondering whether it's going to contaminate, for example, French case law or wherever in the world. But also, we can see now that financial services are targeted on parents' company regulation. A French bank, BNPP, has been recently served with two formal notice by NGOs on the basis of the French and on the European corporate duty of care law. So it's happening because on one hand, the NGO are asking for the bank to cease financial support to a client on the grounds that it was contributing to deforestation. And on the other hand, the bank is asked by the NGOs to stop financial support for a new fossil fuel project and to comply with the objective of 1.5 degree we were talking about earlier on. So, I mean, we all are wondering how far is it going to go? It's really the question.
Great. On that, and final thoughts. Susan.
Well, one of my final thoughts is this, and it's perhaps a little bit controversial, I don't know, but law firms like companies all have their marvelous ESG credentials, diversity and inclusion, aren't I lovely? And there's they're all lauding themselves for how good they are as a firm, as a place to work. And yet, we have seen examples of lawyers within those firms acting for clients who are accused of some quite awful things, who in their day jobs don't appear and sometimes are colluding with their clients in the way in which they run the litigation. So we've had a couple of examples of that recently. One was Waitrose was involved in a dispute supermarket in the UK, and their lawyer sent them a WhatsApp message to saying, basically, burn your documents because you'll be in difficulty. He has been rebuked by the SRA. And then we've had the post office case, which was a horrific scandal which led to claimants committing suicide because they were so under pressure about being accused of stealing money. And there's a big inquiry going into that at the moment about the actions of the law firm representing the post office. And for all the diversity and inclusion credentials of that firm, generally, which are magnificent, their behavior is being revealed as not great in how they behave within the litigation. And I think we need to just start asking questions about making sure that we, as the advisors, behave properly and draw the line and say, this is not good enough. And if necessary, say, well, they're not listening to my advice, I'm coming off the record. We see people saying they won't act for tobacco companies, or they won't do this, or they won't do that. That's a step by not acting in the first place. But what about when you're in the case and you've seen this bad behavior and then you actually take part in it? And I don't think we're questioning ourselves enough about that.
Yeah, it's interesting, isn't it? There is definitely, and some of it, some of it's generational. There's a definite normative change coming through, and in due course, it's likely to reflect also in the courts, in the way that within the political decision makers, within the legislators. So, interesting times. Simon. Do you have a last?
So I think my parting thought would be, given the jigsaw of regulation that we've mentioned, and one we didn't really talk about with the EU Corporate Due Diligence Sustainability Directive, I think it is, how is compliance going to be measured? Because I read two interesting things recently. The first of which was that there's a huge drive by lots of nation states to solar power to reduce their carbon emissions. That sounds like a laudable aim. You might put that on your ESG criteria. That sounds like a good investment. 80% of the supply chain for solar power, so from the polysilicon to the panels, is made in China, in particularly in the Xinjiang region, where most of the labor is forced labor from the Uyghur population. So how do you reconcile that? And then you might think, well, what else can I invest in? There's electric cars. By 2030, there's going to be 12 million tons of lithium-ion batteries that are of no use anymore, that cost huge amounts of fossil fuels and other resources to produce. Are these things that in 10 years' time, people are going to be saying, oh yeah, we know we said solar power was a good idea, now we're saying it's not a good idea, and your objective in trying to meet 1.5 or reduce carbon emissions is now something you're liable for legally. I think that's what's going to be interesting in the next 5 to 10 years.
Uplifting thought. Élodie.
Well, if I may add, we may say that although the framework for ESG regulation is gradually taking shape at a European level, at a French level, the thing is the multiplication of texts and their complexity is likely to make their operational implementation for companies tricky, since the scope of the application of such regulation, it differs. The date of entry into force, the criteria to be identified, etc., etc. It differs from one text to another. So, of course, it's going to take time for companies to implement such regulation. And when they start to implement one regulation, then another one comes. It's a never-ending game.
Great. On that, we conclude. Thank you so much for your attention. Questions? Are there any questions?
Oh, well, yeah, one quick question then. Earlier this month, a group of US senators said that they intend to start challenging corporate ESG policies on antitrust grounds. And around the same time, a fairly eminent and well-known US litigator gave a speech in which he declared ESG to be over. So are we going to start seeing pushback against some of these policies and a rollback, where we're following several years of growing interest in this area?
You were talking about that before, weren't you?
Oh, yeah. Well, I'll take it a little bit. I'll pass it on to Simon. So I think, the ESG, especially in the US, the whole agenda is currently under, it's under significant challenge politically in those parts of America where, the premises for the ESG movement or climate change theories are fundamentally challenged. So, I think that there probably is some political testing, and I think there's a fair bit of opportunism around that, around those political tensions. But I would observe that, sort of broadly speaking, in the financial markets and politically, outside relatively niche areas in America, there seems to be broad consensus around the necessity of having ESG somewhere fairly core to operations of companies, as well as this, I mentioned at the beginning that, if it is understood in the EU, certainly is the case, I think increasingly in the UK, that climate change is seen as an existential threat. And so the political agenda is harnessing the capital markets to fundamentally change the way that production is powered, or the way that we consume, or the way that we produce. So I think that the ESG in the short term, it may be challenged in the short term, like there'll be controversy around it. But I think that fundamentally, things are going to change. And I think that it's going to stay core to both companies and to legislators. Simon, do you have any views?
Yeah, I'm going to be a doom monger again. 1.5 degrees, it can't be met. It can't. That's my scientific opinion, and people know that. And there's a tension there between trying to set an aim that you can at least target. And the good side of that is that it will start to change people's behaviours, and I think it should. And I don't think that will go away, even if it's not necessarily going to be effective in the short term. There should be, and will be, I think, a move to a more circular society where we recycle more, we reuse, and that is a necessity now. It's not a luxury to do that. It's a necessity. But there are some real, and medium and long term, I think that's where ESG will go, because it has to, as you say, because it's an existentialist threat. In the shorter term, I think there are still struggles for businesses to comply, given their embedded supply chains and what you might call the realities of some of those supply chains as they stand, at least, and consumer demands. And also, talking about it from a capital perspective, people's pensions are based on large stocks that are stable, that grow and pay out big dividends. Stocks like Shell, British American Tobacco, they're big payers, and it takes time to readjust portfolios and expectations around those levels of income. So is it dead? No. Politically, obviously, it's a very tricky and partisan subject. No, ESG is alive and well and will continue to be.
That's great. Thank you.